today is now being. All right.
Okay, are we ready? All right. So thank you, everybody, for being here. Thank you for your patience. As you all know, hopefully you all can hear me. During various conversations when employment matters come up, there have been some questions that the board has raised about how we are proceeding and should this be the way we are proceeding. So you asked for this workshop. And if we can go to the first slide, please. The basic purpose of this workshop is to review what the questions are that have come up, focus it really on the question of how to manage employee resignations when there is a resignation issued. We've talked about during the regular year, we've also talked about resignation in lieu of termination. The primary question today is going to be looking at the question of resignation in lieu of termination. And as you all know, the board's primary means of governing the district is through these policy discussions with the administration or in the process of actually approving formal policies for the board. So that's a brief supplemental overview of our purpose tonight, in addition to what the board president and superintendent have shared. I'm going to start the presentation. Next slide, please. Just going over some key rules that govern dismissals and resignations. This is not meant to be the waterfront, and what I'm not going to talk about is when we have separations that are related to reductions in force. That's a whole different topic, but that is not tonight's topic. So what I would ask, after I go through the rules, as the superintendent requested, please, if you have questions, just kind of note them. Once we're through with that, we will pose the question to the board and provide the district's administration. That's a time for dialogue and questions at that point. That will help move the presentation along efficiently, I believe. So really basic general rules. Employment at the district is at will unless there is a written contract, a statutory provision, or other sort of mutual understanding between an employer and an employee that employment is something other than at will. At will basically means we can hire and fire as we please, right? Unless there's something else that's going to control. Principals under the school code are required to make recommendations for retention to the superintendent. The superintendent's responsibility is to then make recommendations to you as a board on the question, and it is your decision as a board to decide whether or not somebody should be separated from the district. These principles of just kind of governance as to whose role is what are already in board policies 2101, district governance, and in 4109, line of responsibility. Hopefully the links in the presentation for those of you that have access to it will take you to the direct policy. If not, it is available on the board's general policy website. At-will employees, as I mentioned, can be dismissed anytime for any reason. All employees also can be dismissed for cause or if the law allows it. Various procedures for dismissal are going to depend on what board policy says, if there's a collective bargaining agreement that has language that governs it, and all of our collective bargaining agreements speak to discipline and grievance procedures. If there's some language in an individual contract, an employment contract term may sometimes say, you know, if there's going to be an early termination, how that proceeds, and if there are state and federal laws that come into play. Under the school code in particular, there are certain mandates about employment in schools. First of all, if you do not have a proper teaching license for the assignment that you hold, you cannot work in the schools. If you don't have a teaching license and you are assigned to a position that the school code says requires a teaching license, you cannot hold the position unless you have like the sub-license, or we do still have licenses. You do have a valid license with stipulations if you might be working towards something. You still then are properly licensed. But for example, I have my law license and I have a social work license or I had a social work license. It's been reserved at this point. But I couldn't go in and teach a class on social behavior. I couldn't teach a class on English because I'm not certified for that or licensed for that. Also, if you have had a conviction of certain crimes that are usually felony offenses within the last 7 years, or more serious offenses such as murder, aggravated offenses using firearms, those types of things, you may be prohibited from employment in the schools, as well as drug offenses, unless it's a first time and you've gotten probation and you have successfully completed that probation. Those are black and white rules in the code. If those facts exist, you cannot work for the schools. If that were to come about with employees that are already working for us, that would be grounds for pursuing their termination and dismissal. Also, if the juvenile court has identified an individual as a perpetrator of child abuse, you cannot work in the schools. The school code was recently amended to say if DCFS has made an indicated finding of abuse or neglect, we must consider that in the employment process, but that's not a mandatory can't hire. We have to make a judgment call as to whether it's appropriate for them to be hired or not. When you are a tenured teacher, one other mandatory provision is if you have gone through an evaluation process, you scored unsatisfactory, you were given a 90-day remediation plan as required by the school code and the evaluation plan put in place with bargaining agreements, and you do not complete that with a proficient or higher evaluation, you are to be pursued for dismissal. So those are some of the mandatory dismissal rules in the school code. The next side of this slide speaks to when the school district must report instances of misconduct to the State Board of Education. They're going to somewhat mirror what you heard for mandatory lack of employment. If there is a pending criminal charge or a conviction of a prohibited offense, then we must report that to the State Board of Education. They will then determine what to do with the license. If an employee is dismissed or otherwise resigns for reasonable cause that is related, we believe reasonably, let me rephrase that. The employer reasonably believes the resignation or dismissal was related to an intentional act of abuse and neglect or an allegation of sexual misconduct as defined by Faith's law, then we must report that to ISB so they can take a look at the license that that individual holds. Briefly, there's a detailed definition of sexual misconduct under Faith's law, but just very generally, it includes grooming, it includes sexual harassment type behavior, inappropriate sexual contact between teachers and students, or exposing them to sexually inappropriate materials. Next slide. When we talk about ESP dismissals, and ESP means educational support personnel, and it pretty much applies to anybody other than somebody who holds a license, professional educator's license. Boards have general authority explicitly in the code to hire educational support personnel for a variety of different roles. There is no specific statement in the school code about your authority to dismiss them, but there is a general rule in the code that the courts also rely on to support your authority to dismiss individuals who are educational support personnel that says you have the authority to implement any rule that you need to in order to implement anything else in the school code. So by implication, that rule gives you the authority to dismiss educational support personnel. There is one provision specifically when it comes to making reports of child abuse and neglect. If a non-licensed staff member, so that specifically does not apply to licensed teachers, so it's the non-licensed staff, you may, you're not required, you may immediately dismiss for willful or negligent failure to report suspected abuse or neglect. And negligent failure to report involves if the employee during their job, during their official duties, personally observed an instance of what they believe is suspected abuse or neglect, they reasonably believe it is abuse and neglect, and they failed to timely report it. It says immediately. Immediately doesn't mean it happened at 9 o'clock and at 9:01 I reported it. You may not be able to immediately get to your computer, but it is as soon as practical afterwards, and we would expect it to be within no later than the end of the day, and even closer to that at your first break, you would be reporting that. I do also want to just remind people, if multiple people are aware, every person who has knowledge that works in the school, your duty is to ensure at least one of you has reported. So if all of us here knew, and I knew Amanda reported, then I have done my duty because I know it's been reported. But if I saw it happen, and I don't know if any of the administrators at the table reported, then it's on me to report, and everybody else to find out, hey, Kathy, did you report this? So if there's ever a group situation, my recommendation as an aside is always make sure you know who's going to report and then follow up that they did. Because we have this language that says if you willfully or negligently fail to report, you may be dismissed. Next slide. When it comes to teacher dismissals, the school code is more explicit. The general rule is on the left. You have the authority to dismiss a teacher for any of these reasons: incompetency, cruel, negligence, immorality, other sufficient cause, on the basis of their performance not meeting expectations. That really kind of ties into that evaluation piece in part. Whenever, in your opinion, they're not qualified to teach, or whenever you think it's in the interest of the district to let the individual go. But you have to make those decisions within the context of what the law requires, the bargaining agreement, and with all of our bargaining agreements, just cause. Egregious misconduct also is called out and is something that very specifically, if it's egregious, my word, but with tenured teachers, it is, the school code will speak to remediable. If it's irremediable, we can move to dismiss without having to show we've made efforts for improvement and changing behavior. Or when you're in the evaluation context as well, they have acknowledged that through the evaluation process, if you learn of irremediable deficiencies in performance or actions which are injurious to or endanger the health or person of students in class or at school, that is grounds for moving forward immediately with dismissal. So this is where the code is giving you some authority to take action when the facts of each case fits in. Board policy then has considered a lot of these different rules, and in Board Policy 4302, we identified egregious misconduct. And what we identified as egregious misconduct is listed here: theft when it's over a value of $300, whether that's money or property or conversion of funds. If you lie or make materially false statements or misrepresentations in formal investigation about your own employment qualifications, which is another reason that the school code says if you don't properly represent your qualifications, you can't work in the schools, and they can pull your license. Various sexual misconduct, including face loss, sexual harassment, engaging in intentional physical harm to students, convictions for crimes for which you can't work in the school, and other conduct for which there's irreparable harm to the district or irreparable harm to the reputation of the employee. And that's all built into our code now. I'm going to shift over to what the school code says about teacher resignations specifically. You really have to think of this in 3 buckets. The first bucket is the general bucket. Any teacher can resign at any time as long as the board says you're okay with that. So they would bring it to the board. If you say, yep, we're good, they can resign. That's bucket 1. Now you break that down. If a teacher comes to you as the board in the middle of the school term and says, I would like to resign, 2 weeks, 30 days, 3 months, but sometime before the school year ends, and we have knowledge that they are resigning to take a teaching position someplace else, they may not resign under the school code unless the board agrees. So the board can say, no, that's not in the interest of our district. It's not your professional obligation to us. We do not agree. And if you don't agree, you also can determine to refer that teacher to the Illinois State Board of Education for review of their teaching license for unprofessional conduct. The state has through it's a combination of the State Board of Ed and the teacher certification departments will look at that, and they have the authority to suspend that teaching license for up to 1 year in the school code. This is a conversation the board had, and last January, I think it was, you confirmed that you supported moving forward with those referrals. In those instances, if a resignation came to the board and the board did not agree to allow the resignation, and we knew it was for the individual to take another teaching position. This isn't a situation when somebody's taking another teaching position because the family's moving to Iowa. That's the resignation, we're moving, and yeah, I'm gonna continue my career. This is the situation where, hey, I found another teaching position within driving distance of my current job, and it pays me better, I like that district better, I've been trying to get there, whatever the reason is, during the school term. The third bucket is during summer session. Summer session is after the last day of school in the regular school term until the first day of student attendance. The school code is very clear. It says that you can submit that written resignation, it should be to the superintendent in writing. But if it is within 30 calendar days of the next school term starting, the first student attendance day, then we treat it as if you are trying to resign during the school year. The rule helps support stability in employment to have all of your classes filled at the beginning of the year and not think you have it filled and then suddenly you don't have a teacher for 2 or 3 classes because they held out and they got a better offer someplace else. When we look at how these resignations are dealt with in the bargaining agreements that govern our licensed staff, that's the teacher's agreement and the psychologist's agreement, they both use the same language. They expect the teachers, and this is a quote, to uphold the law and professional standards in regard to official resignations and procedurally follow the school code. Board policy has that same timing consideration in it, but it also has a statement that says the board will accept a resignation as long as we get 30 days prior notice, and it is not a resignation during the middle of the school year in order to take another teaching position. That used to be in the school code specifically, that 30-day language. It is no longer in the school code. It is any time you can resign with board concurrence, but they don't conflict. So this might be something at some point, if you feel you want to change that language in your policy, you can let us know, or the administration may make that recommendation, and then we would bring that policy change forward. But right now, it's all in alignment. Right, hold your question.
No, I just want you to rewind what you said.
The board policy currently says if we get the resignation with at least 30 days' notice before it's effective, and it is not during the school year, the board will accept it. The union bargaining agreement says you need to resign following the school code procedures. It wouldn't have that 30-day piece because the law changed a couple years ago. But the policy does not conflict with the change in the law. You can leave that language in. You can direct that we ought to rethink this. So I just wanted to make it clear it's not a conflict, and it is a current policy statement, but the controlling language is going to be the bargaining agreement, which says we're going to follow the school code. Okay? Then we have ISB's licensure review practices. Next slide, please. ISB, like many of us, prioritizes what they have to focus on when referrals come in the door. They prioritize on these 3 issues based on conversations I've had. When the allegations involved harm to students, including sexual abuse or physical abuse, if criminal charges have been filed, they may not act on it in terms of anything long-term at that point, but they may suspend it pending resolution of the criminal case, and that may also depend upon what is the nature of the criminal charge. Just don't have that level of detail. All of these decisions are individualized and fact-specific. And the third one are the resignations during the school term. That is what they prioritize. So the primary question for discussion tonight is, should resignations in lieu of termination be limited? Remember, we already had talked as a board about the concept that if somebody resigns during the school term and the board does not agree with that because, and they are going to take another teaching position, that you concurred with referrals to ISB to look at those. This question, therefore, is, should resignations in lieu of termination be limited? And the administration's recommendation is yes, they should, in those cases when the egregious misconduct involves behavior that has to be reported to ISB. So that's their position. That is what they would like you to discuss. And the point of this discussion tonight is whether you agree with that position. Yes, please.
So we've had a lot of conversation as a board of when to accept resignations. Oh, sorry. We've had some conversation as a board of when to accept resignations in lieu of terminations. Our recommendation is to not accept the resignation when the act is egregious and needs to be reported to ISB. And that is on slide, what number is that, where it's at? I pulled it out, but.
I think it's the 6th one. I couldn't figure out how to put the page numbers.
It says school code mandates, and, am I correct? Yeah. And so what that entails is pending criminal charge or conviction of prohibited offense, reasonable cause to believe, intentional act of child abuse or neglect, sexual misconduct, and sexual misconduct. And license holder was dismissed or resigned. So I'm just reading everything she has there. So that is our recommendation. We turn it over to you for your guidance. Did you have a question?
Yeah,
Yeah, you were reading that one, but we have a specific slide on egregious misconduct.
Yeah, it's in there several times.
Okay. Which slide is that? That's why I asked.
Is there a second one?
Yeah.
Left over
Is that the
$300.
board policy? Board policy, all staff?
Egregious misconduct, theft over 300 line.
Before that also is
The board policy, all staff, is what we have identified in the policy as egregious misconduct.
Okay.
And we pulled a lot of those and identified them as such because they are things that the school code really also identifies as being significant concerns for which that's an appropriate consideration.
Okay, then I got mixed up on the slides. I apologize. So Kathy, are you saying this is the slide? No, it's the previous one, right?
We have the correct slide.
Mechanism. Right. Yeah. So what we're saying is what ISB states that we need to report, that is where we should not accept a resignation versus a termination. However, when Ms. Vanderbroek explained this to me, she says we have 3 things moving, and I'm going to miss one. One is our policy, one is the statute, and the third was?
Bargaining agreement.
Bargaining agreements,
Language.
thank you.
So this page that says school mandates, on the left side, you have when we can't have people employed. On the right side, you have what we must refer to ISB. Does that clarify? And I'm standing because as you discuss, I'm going to go over to the board and capture your comments. Ms. Hannah?
Okay, I started writing, you know me, I would rather ask when it's being talked about, but I'm going back to the general rules. And employment with the district is at will.
Yes.
And my question for that is this a state law or is this district?
It's a general employment law rule. All employment is at will unless there's a contract that says I have a right to be employed for a certain period of time. Using the collective bargaining agreement as an example, that is a contract that says you can't just dismiss me for any reason. You can only dismiss me for cause. Or there's a statute that says you can't work for me. So if we learn somebody has been convicted of attempt to distribute drugs, then they can no longer work for us.
Right, so you say it's a general
It's a general rule.
rule from where?
It's a general employment rule.
Is that only in
It's a general
Illinois?
employment, no. It's a general employment rule across the board. We, in this district, do not have a policy that says that statement, but the Illinois Association of School Boards does have some policy language that speaks to employees at will. Usually that's your educational support personnel, but we also have to consider what bargaining language is there. We have a policy that says when we appoint staff, generally you're going to be appointed for a year so that we have stability in employment. I didn't put that policy in here because this was about separation, not employment.
Okay, all right, and now going to the next point. Principals make retention recommendations to the superintendent. Aren't there deadline date requirements for,
Yes.
for,
There are for probationary teachers, if you're going to non-renew them, but this presentation wasn't about that.
No,
which is
no,
why
I'm
they're
just
not in here.
talking in
But
general.
yes.
okay. What is non-negotiable duty?
Non-delegable.
Delegable.
That means that you can't tell the superintendent, fire this person.
Oh,
That means the
Okay.
board has to make the decision.
Right.
The school code says it is her job to make the recommendation to you. It's not your job to make the recommendation to her. You hire her to run the schools. It is your job, though, to act on what recommendations she makes.
so if under general rules, I've flipped the page. So, procedures for dismissal and determining cause may vary. And under board policy, my question is, can a policy remove that at-will clause? And I'm,
So I'm pausing because if the policy reflects a statement of the statute that says you can't work for the district, if you've had this conviction, like your criminal background check policy has, then I can't hire you or I can't keep you employed. Whether you are at will or not is going to depend on your job. If you're a tenured teacher, you have tenure protections.
right.
That's not going to go away. That's going to control over at will. If you have a written contract that says we hire you from date A to date B, I can't have a policy that then says, but if I feel like it for some other reason, I can get rid of you, but if I have just cause, I
Right.
can't. if my policy speaks to reasons that we could pursue recommendations for termination, then, remember, at will is I can dismiss you anytime for any reason. So the policy isn't really going to take away your at-will status. The policy is going to put you on notice. If you engage in this behavior, you might have a problem with continuing employment with us.
Okay. Can I finish my questions? I just wrote some things down as we went along,
Okay?
okay?
That's what we asked you to do.
And now I'm at school code mandates.
Can I just pause a minute? Mr. Riddle, was your question related to what she just asked about, or is it something different? Okay, can we let her continue? We'll go after that then. Thank you.
Then I'll be done.
Okay,
Okay.
mandates, yes.
Yeah, how are we, okay, if you talked about, I guess you were speaking of teachers,
In some of them, not all.
okay, we're under employment prohibited when? That's what I'm looking at.
Right. The
Okay.
teaching license is clearly going to be your teachers or administrators who need to have a teaching license.
But you
And
ta-
then your evaluations is going to be teachers. The other two could be any employee.
Okay, but my question is, how are employees being placed in positions that they are not licensed for? And I'm going by what you were saying, that they have to be licensed for social studies.
Right.
Or science.
I'm going to let Mr. Figueroa give you some examples of when that has come to light and how that's come to light.
We might have provisional licenses, like in the case of transitional bilingual teachers, those are good for 5 years. After 5 years, that license will expire, and they need to have completed coursework and licensure requirements by ESB, so they will be able to obtain a new license. So that's a possible case scenario. The other possible case scenario is a teacher who is licensed in social study. I think she mentioned social work as an example to herself. She's a social worker, but she cannot teach certain classes just because
Right.
they're associated with her title or license.
Right.
But ESB regulates the requirement for the other position. So if a principal move a teacher from one position to other, the other one is not qualified for that new position, but then that person cannot hold that position. Failure to also to comply with licensure, because the state have some bureaucratic timelines and what it takes for them to process requirements. At the end of the day, the person is found that doesn't obtain the license for the position, then the person cannot continue in that position.
Okay. And I'm still on school code mandate. Thank you, Mr. Figueroa. Under superintendent notification required when license holders, does this mean all of the, okay, it says pending criminal charge or conviction of prohibited offense, right? Mm-hmm. And it talks about, and I mean, I guess it's kind of elementary, that we're talking about students, right? But-
No, the first one for pending criminal charges is if there's a pending criminal charge against the employee, then we can't, and that employee holds a teaching license, we are required to report that to the state superintendent.
But my question is, does that mean adult victims too?
It's the criminal charge, irrespective of whether it's an adult or a student.
Okay,
If the state's attorney has issued a charge, that's what they're talking about.
okay, so.
In terms of a pending charge, and then if you are convicted, that means the criminal court has looked at it, and you've been convicted of the crime charged.
Okay, but I'm talking about adult victims of the pending criminal charges if it happens in the district. That's what I'm saying.
It doesn't, so let me rephrase, because maybe I'm catching this correctly. Are you asking if I'm the victim of the charge, can I be dismissed?
No, no, no,
okay,
I'm
good,
not asking that.
Good,
No, no.
good.
No, no, no.
No, the charge doesn't have to be against a child or an adult, it can be either, and it doesn't have to have happened in the school setting, it can be any place.
Okay, so I think, I'm not sure, but, and all through the thing, I'm looking for, things that like would cover, adults, staff members. And I'm not seeing that, I'm just seeing students, referencing students, but not, staff.
So, yes, I think it is true, we don't have a statement, for example, in the school code that says if you sexually harass another staff member, you can't work for a school district. But we do have rules that say if you engage in sexual misconduct with a student, refer that to ISB because they're going to look at the license. So what you have here is what the school code has determined as a matter of public policy. If you engage in sexual misconduct with a student, that is more egregious in a school setting, and you shouldn't be able to work in a school setting than if you engaged in sexual misconduct with an adult. But that doesn't mean, this is important, it doesn't mean as a board or administration you can't determine that is not appropriate and in the best interest of the district. It doesn't mean that's not rising to the level of irreparable harm, and you should not work in the school setting. You have that discretion. But it is not
It's not.
required to be reported to ISB.
It's not written.
Not
In
in the,
our
not in
policy.
the school code. Our policy, where we talked about egregious misconduct, follows pretty much what the school code tells us. So we don't have that provision, for example, explicitly stated, but remember, for egregious misconduct, we have a provision for other conduct that causes irreparable harm to the district or your reputation.
And so should our policy speak to that? Because if it's silent in the policy, basically, we can do the interpretation of the policy. But in my opinion, I think it needs to be made clear.
And that is for discussion of
For
the board
discussion with
and
the board.
feedback to the administration
Right.
on
Okay.
that point, okay?
Okay,
So, did you catch that one, Amanda? So Amanda's caught that question.
Okay. Oh, and you know, we were talking about like being like a mandated reporter.
Yes.
Right? Does that also include board members as
The board member's duty as a mandated reporter is to report it to the superintendent and direct her
Okay,
to have it filed. If you don't want to file it yourself, you always have the right to file it yourself. We can't, though, employment rules don't govern board members. You're elected officials. I don't believe, but I can double check, that there's any rule that says if a board member knows about child abuse and neglect that they've learned while sitting as a board and doesn't report it, that is grounds for them being removed from the board. I don't think that's a written rule.
could you look into that?
I will
and
look
see
into that.
where we stand with that? Because I've been told that I'm a mandated reporter.
That is true.
Right, right, I know that, but to what extent?
Okay,
Yeah,
yeah.
yeah, okay, okay, I think that's everything I wrote down. Oh,
Can I go to Mr. Riddle, and if you have another
Sure.
question, we'll come back?
yes.
Mr. Riddle?
Okay. First, I want to make sure I understand
There you go, it's on.
Okay. Okay. First, I want to be clear that I believe that, Ms. Vanderbroek, you stated the purpose of the meeting was to clarify with the board and what the board wants as a policy for when resignations in lieu of termination should be limited, correct?
Correct.
Because in the past year, there has been the board has brought up some instances where we have had individuals brought to us for resignation, and then when the board has asked why they are resigning, we found out it was in lieu of termination. So the board was not clear that that was always being done, that we were not clear that every resignation that was being brought forward to us, that some of those were in lieu of termination. That was one thing that
Correct.
happened in the past year. And the board said, with some of these individuals, we felt that maybe we should terminate, some members of the board thought we should terminate and not allow resignation in lieu of termination, correct?
Yes, there
Okay.
were different instances when you felt that that
Right.
shouldn't be an option.
All right, and one of the considerations that I thought, first off, the principal makes the recommendation to the superintendent, and the superintendent makes a recommendation to us for either resignation or termination, or resignation in lieu of termination, correct?
That is what the school code sets forth, but also any of your administrators
Yeah.
could work through HR, and HR is another significant source of supporting or weighing in on whether termination should move forward.
Okay,
And-
so I have several
yeah.
questions. If I could just kind of briefly go through those. One of them is, at this point in time, is the superintendent obligated to tell the board that a particular resignation is in lieu of termination? Do we have that clear in board policy at all?
That is not written in board policy.
Okay, I think that's something the board should consider tonight, is whether we want every resignation that is in lieu of termination brought to our attention and
Yes.
explain why this is being done.
Yes.
That's important in my way of thinking, and I want the rest of the board to understand that.
Yes.
The second thing I want to ask is basically just a brief question, because it's a big district with 2,000 employees. I wonder how many times in the past year an employee was offered the chance to resign in lieu of termination.
Can I give some context?
Yes, please.
Yes.
And I don't have the data.
I'm not asking that you give
Right.
it to it tonight.
No,
Just-
no, we can get you that. I just
Right.
want to say, so I just want to give some context. This is not a new way that we've been handling this. This has been a
Right.
way that this district has been handling this prior to my arrival. Am I correct, Mr. Figueroa? Yes. So the reason we're having the discussion tonight is because I'm looking for the right word, because there has been some discussion, and certain board members feel it should be handled this way, and others may feel it should be handled this way. The administration is looking for direction from the board
Right.
on how you all would like to move forward. So if the ask is, we would like to know anytime there's a resignation in lieu of termination, we like to know that during closed session, we can prepare that for you, no problem. The second piece, and I'm gonna let you finish. The other piece to this is, the question has to be answered, do we keep allowing employees to resign in lieu of termination at all times? Or is there some things you're gonna hold firm on saying no on hypothetically sexual abuse, sexual misconduct? We are not accepting your resignation. We are going for termination. And that's the direction we're looking for here, for you all to set a new standard where you all are in agreement so that we have clarity on how to perform our job at the best we can for you all. That's
Right.
what we're looking here for.
Right. And from my understanding of briefly reading the law, the faith law that came into effect says that we cannot allow staff members to resign in lieu of termination when there has been sexual abuse to a child, to a student. And of course, legal has to clarify that, but as I looked at the law, it looks like that is the, what it came into effect, and it requires that, that be reported to ISB and that we don't pass those people on to another district.
Right.
If they have been found guilty of sexual misconduct with a student, that we don't, our hands are now tied because of that law. So that's one question. You don't have to answer all these questions tonight. I'm just bringing these forward. I also know a consideration, or at least I presume a consideration about allowing individuals to resign in lieu of termination. Now, I'm not just talking about the sexual abuse with the faith law. One of the considerations is how much is it going to cost the district if this person sues us? And is it worth, you know, if, now we're not talking about the faith law, I'm just talking about this individual. We could terminate them, but we're gonna offer them the chance to resign. Do we take into consideration the financial liability here? And is there a threshold that this district uses to say, well, this could cost us, for instance, $100,000 in legal fees, just as we would in workman's comp cases, we negotiate, and in this sense, you kind of negotiate with the individual and basically allow them, do you want to resign in lieu of termination? I'd like to know what our threshold is in the district and if that is a consideration that we make. Now, I understand the district is wanting to use this recommendation, egregious misconduct, and when I look at that, I see theft over $300.
No, they don't want to use that one.
Oh, they're not using that one?
It's the ISB superintendent.
It is egregious misconduct that also aligns with what must be reported to
Okay, so
ISB.
that's the one before that, so that's irreparable conduct or performance deficiencies
No, I know
or
what you're
actions which
saying
are
with
injurious to the health
Oh,
or
yeah,
person
yeah,
of
yeah, I
students
got
in the classroom or the school. Is that, am I on the right?
Absolutely. Absolutely.
Yes, that's what I'm looking at.
No, you're not.
It's,
They're
it's,
looking at school code teacher dismissals, they're looking at school code mandates.
and then we're,
Three different sections.
Oh, there's
of
three,
the
okay,
code.
it's this one, pending criminal charge or conviction, that one?
Yes, yes.
Okay, I'm
Right.
looking at the right one. Now, that's what you want to use, that one.
Right.
I want to be
Yes.
clear on that. Okay, pending criminal charge, I guess I have a question on that because I've thought we've had a pending criminal charge we can't actually terminate because we could be sued if they were found not guilty. A conviction, yes, but a pending criminal charge, I know in the past, we have held off termination.
Yes.
Because the charge, and we asked, why are we holding off? Because there's a serious pending criminal charge. Why are we holding off termination? The board felt we should terminate, and we were told not to terminate because
Yes.
this person could be found not guilty, and then we'd be sued.
so I'm not giving a peace sign. I have two things I want to comment on, Ms.
Right.
Lensing, before you weigh in. The law states explicitly that you can either terminate or accept a resignation of an employee who's been engaged in sexual misconduct under Faith's law. So though they don't say you must terminate and that you can't take a resignation, that is a separate question from whether or not to refer them to ISB. It also says, if they engage in that behavior and resign or end up terminated, then you must report them to us. But they can do either under the law. So that's that point.
That's, so under faith law, you're saying we don't have to terminate and they don't have to resign,
But we have to report.
but we have to report.
But if they resign, so if Mr. Figueroa went to an employee and said, we have an allegation that you engaged in this misconduct, this could be grooming, we're going to open an investigation, you're going to be on admin leave pending investigation, and 2 days later, we get their resignation, you could decide to accept that resignation as the board, and then that would trigger them being reported to ISB.
Okay, all right,
And whether we finish the investigation or not, that goes to ISB.
okay.
Okay, that's that. Your second point about pending criminal charges. The law used to set it up in the case law decades ago, that if you take action on a pending charge, you might run into trouble on that. So we let people sit on admin leave. We kept paying them for long periods of time because the criminal law can move slowly, especially if there's not a settlement. It did change to specifically allow for us to dismiss them pending a criminal charge, but if they're not convicted, it also says you have to give them all the back pay. So that's a compromise. You do then, the only other new law that's out there, and this goes to the process, it doesn't go to whether or not, is you have to be careful when you're acting on arrests and information of arrests and convictions to ensure that you're not acting on any kind of potential discriminatory manner under the Illinois Human Rights Act. And they set up, there is language that allows, you aren't discriminating if you dismiss because a law says you must, like the reasons we have here for those various criminal charges. And then it says if there's a conviction that you think is directly related to their duties, you have to think about that. And that might warrant dismissing or not hiring, either one is another option. So there has been some changes to the law that have tried to kind of bridge that gap and create a more equitable situation for both sides.
Okay. When I look at this, what you're recommending right now, this, under that section, is be superintendent notification required, that's where we're recommending termination in lieu of resignation. In other words, I thought in the past, lying was considered, egregious if there's an investigation, and that we would want to, the administration would want to terminate for an individual when an investigation is going on and they are deliberately caught lying to us, trying to foil or, because then we can't trust our employees after that. If they start lying about and we're just investigating matters that are serious, is that no longer considered a reason to terminate in our district?
Absolutely. We would still go for termination. The difference there is that we would allow them to resign. If they said, okay, we're going to go for termination, and the employee said, our recommendation would be, well, can I resign? We would allow them to resign in those cases
Okay.
because that's not a reportable offense to
Offense,
ISB.
okay.
So we're not changing how we handle that.
All right.
Right? What we're talking about here is the discussion around when does the board not want to accept the resignation and want to move forward with termination?
Okay.
And Ms. Lenzine had her hand up
Yes.
for a minute, so I just want to recognize that.
Sure. Well, I'm back to that. I'm not real clear on those 2 points here. And I felt that the board, when we have discussed this a little bit, the past year, when if there was sexual misconduct with adults, and Ms. Hannah was bringing that up, very serious matter, and that would be, not be one of these instances where we could still, I guess, are you saying
I'm
the board?
confused
It
with that
is,
too.
it-
Mr.
it-
The
that,
board would
that
not-
is,
That's our decision.
that's your,
That's our
if you want to
decision.
give us that direction to add that to the list, you can do that as
do
a
that.
board,
To add
to add
adults.
that.
Yes.
If there's sexual misconduct between adults,
We gave you a snippet of it. You could add more. You could take less. That's why we're having the workshop for
Right.
you all to give us
Right.
direction.
Okay.
We're giving
I
recommendations
see.
that whatever ISB says we have to report, you should not all take the resignation from them. You should say, no, we're moving forward to termination.
Okay.
Because part of this for the board, and I think it's important because of the workshop, is you want to be good neighbors and good stewards to other children in surrounding communities.
Right.
And this is where this is coming from. It's not, it's for Waukegan, but you want to make sure that all students are safe in the state of Illinois or in any other state. And
Right.
that's where this came from. This is the foundation of this.
Okay. And I guess adding then, I guess I like that, going down a few to the egregious misconduct. There's a few of those that are very serious, and I'd like the other board members to consider, for instance, that very last one where it said, other conduct for which there's evidence of irreparable harm to the district or irreparable damages to the reputation of the employee. And since we're talking about people who are highly respected in our district, our administrators or teachers, individuals who work for the school district, and if they do something that, there's conduct there that's irreparably harming the district or damaging the reputation of our district or the employee, it seems to me that's very serious conduct. I wouldn't, as it personally, termination would be the thing I would think the board would want, but I don't know, we'd have to decide if we want that written into the policy, is what you're saying, added to.
What is the direction to the board or to the administration in terms of what they bring forward to the board?
Right.
In terms of how they engage in communication with the employees about the particular fact scenario?
Right.
And all of this, as I'm sure you all know, but I'm just going to reiterate it so everybody is clear, this is just general guidance. All cases will be made on a case-by-case basis, but we want to treat similarly situated people in a comparable manner.
Right.
Whether to say up front, Mr. Figueroa, if these situations come up when you are talking to that employee and termination is the recommendation, if they ask you, can I resign in lieu of termination? You need to tell them this is one of those things that the board has directed. The administration needs to bring termination forward to the board, not resignation.
Okay, I see what you're saying.
That's kind of how it would play
Right.
out
And the board can-
practically.
The board can, what you're saying is the board can always go with the recommendation of the administration is, based on these policies, we're going to let this person resign in lieu of termination, but the board has the authority to change that because the administration presents what the rationale was, and then the board can, if they feel, for instance, the reputation of the district has been irreparably damaged, or that individual teacher or administrator has damaged their reputation such that the board doesn't think they can continue in the district or even should work at another district, we could change that and terminate instead of.
So if we brought that forward to you as a resignation, and you said, no, we aren't going to consider it
Right.
as a resignation, please bring it back as termination, you could do that.
Okay,
That's within your right.
right.
And if I may say something.
Yes, please.
What the board is telling us so far is that there will be certain offenses that human resources or the supervising administrator would not even discuss a resignation.
I see.
Or if a resignation is being offered, we will immediately reject it.
Right.
Now, there are other cases where we might have that conversation. My opinion is, and we have been doing that already, is that we will try to bring those cases that are very severe to the attention of the board and seek guidance on how the board wants us to proceed if those cases are not one of the cases that you're identified or that the school code is identifying as that we should go and terminate immediately.
Okay, I have one final question, and I'm going to let the rest of the board talk, and that is, if the board is inconsistent in its determination, for instance, the district lets certain individuals resign in lieu of termination, and we have it as our policy, and we're following that along, but then with certain individuals, we change and change that, that could cause a problem with the individual that was not allowed to resign, correct? Because then they could sue and say.
This is always the lawyer's favorite answer. It depends. Every case is going to be fact-specific.
Yes.
You will have a problem if there is a perception that you are engaging in discrimination and unfair conduct and behavior.
Right.
When your employees believe that, that is when we start to get more litigation, more administrative complaints, et cetera.
Thank you.
Consistency is the best,
It is.
as much as possible.
Yes.
And we have to also remember that every case has many variables attached to it. So we have to look at these on a case-by-case basis. But there's some of them where you can say sexual misconduct, we're not dealing with that. We're going for termination, right? However, there may be another case where you say, well, we would take a resignation for that. But when we discuss the case, the board may feel, you know what? On this case, I'm not seeing it this way. I feel it falls here. That's still your right. That's what I'm trying to say. So you're not locked in. What we need to get locked in is there going to be certain things that we say we're not accepting a resignation on these A, B, and C? That's what we're looking for.
Thank you, Superintendent.
Okay, I just want to first start by thanking the administration. Thank you, Superintendent, for getting this meeting together. I think this has been brewing for a while, so I'm glad we could nail this down. I am very much a safety-first person. And there have been scenarios that have come to the board where it's very frustrating, where we are accepting resignation in lieu of termination. So I think to their point, and I also wrote down consistency, I think the point is to say, to the points already made, if we have general, basic, baseline parameters, if they do this, if they do one of these things in these categories, it's an automatic termination. So it lessens they make a recommendation and we override it. Because the goal is for us to be on the same page. Right. The goal is for you to present something and our thinking is mostly in alignment. Are we gonna agree on everything? No, but to Ms. Vanderbroek's point, we look at those scenarios and she is very good at saying, well, we want to make sure that we are thinking of these things because it could come across a certain way. So with the safety first, I am in agreement that with Ms. Hanna and Mr. Riddle that this does not include staff protections, and that's a concern to me. It should be our students should be safe, our staff should be safe, and our families should be safe. We should not have parents going into our schools, interacting with administrators, teachers, and get verbally abused or discriminated against or what have you, treated poorly, and then for the teacher to continue in that role. I think for me, if you are causing an unsafe presence in our district, you should not be here. That goes for physical safety, that goes for emotional safety, and we can get into the nitty-gritty if we need to. I think personality conflicts, that's different, right? I think if you're in a department and you have a different perspective than your department head, you shouldn't get fired for that. I understand there's language that we have for insubordination, et cetera, and it could be seen a certain way. If it shakes out that they're not a good fit for the district and they were still a safe individual to the school, it's just a disagreement of opinion, let them resign. If you don't like that I'm a direct talking person or that I'm not please, thank you, yes, no, we're not firing someone for that. There are some aspects in here that I still have additional questions on because I know the main point is to identify resignation in lieu of termination and where we limit that. There's just some aspects where it just creates more questions. And if it needs to be a different meeting, that's completely fine. I'm just going through some of my notes. So looking at the school mandate slide, right? We have some, we have the bullet point around employment prohibited when, and it's talking about the qualifications for the license, et cetera. Like we find out on probationary basis, we need to move them, or they're not a good fit, we need to fully terminate. Okay. Are we applying this to international teachers because there have been instances where someone is qualified for middle school or high school but are in elementary schools? I don't need a direct answer, but these are the questions that I want us to be thinking about when we're looking at those. So there needs to be a process in place for that. When we are looking at the ISB superintendent notification required, if we just stick with this list, I don't like passing the buck. I don't like passing the lemons. If you've seen Waiting for Superman, I agree full-heartedly with the superintendent that we not only have a duty primarily to our students, but to future students that this adult is going to interact with. So if they are unsafe, we should terminate, and that's a clear line on their record, and we don't do it just because we don't like you. It's you have committed something serious. So when it comes to the intentional act of childhood abuse or neglect, who makes that determination? Is it solely DCFS? Because if it's solely DCFS, I have personal experience where there are big concerns with that department. It's not fully, they're not fully staffed, they're overworked, they're not following their cases within the required amount of time. So I would like some clarification on that.
So
piece.
on that one,
Yeah.
I think we have 2 or 3 different things to think about. The rule is, if you as an employer have reasonable cause to believe that an employee resigned, or following investigation, we found that the employee engaged in intentional abuse or neglect, that triggers the reporting obligation. If we accuse them and they just leave and we never investigate, then it's a presumption. It's up to ISB to decide if they did it. More likely than not, ISB is going to wait to see what DCFS does. Remember, anybody accused of being a perpetrator can appeal that decision, but if they don't, it's going to stand. So you would have to establish factually it's intentional abuse and neglect, and there was the linkage to resign or dismissed. When they absolutely can't be hired is when we know a juvenile court heard the case, had the hearings. They don't call them trials in juvenile court, they're adjudications. The child is adjudicated, abused, and neglected, and if the perpetrator was an employee or was looking to work for us and we knew that, then we can't hire them, and we could immediately move for their dismissal. And because that is dismissal by law, more often than not, you will get a resignation offered because they know under law they can't work for us.
I'm going to add something, and you may have said it and I missed it. However, anytime hypothetically there's hypothetically a teacher hit a student in the face, hypothetically, DCFS is contacted, a report. We're mandated reporters. We have to file a report. However, we have our own internal investigation. And so that is a piece of it, but it's not all of it. Our investigation, interviewing of all the students in the classroom, interviewing of the principal, so that DCFS report, not in many cases, in some cases, DCFS will come back and be like, it's unfounded. And you have 30 students that say, this happened. So we don't go by DCFS, right? It's a piece of it, it's not all of it. It gives some context, it's a variable, it's not the full situation. So what would be the full situation would be the internal investigation that takes place and the facts that come out of it. Do you want to add?
I want to jump in there. And I think this comes back to consistency, because there has been an example in the district, and I'm not going to name names or specifics, but I am aware of a situation where it came back unfounded. Students, other than the victim, reported what happened. It was documented with HR. There was a follow-up meeting, and then it was denied by the perpetrator, and they continued to carry their job here. So there was lying, and there was still physical abuse in the classroom, and it continued. So it happened, and we cannot tell me that it didn't happen, but my concern is consistency.
Yeah.
So as we're looking at this, I want to make sure that we're clear on what that consistency looks like.
That's fair.
HR will never agree to a scenario where a teacher or any other adult in the district have engaged in physical abuse or altercation with students, and we will agree, HR, to that individual to continue. So, and going back to the statement that the superintendent was making, we don't follow HR in order to dictate our opinion in a case or make a recommendation to the administration.
You mean follow DCFS?
No, DCFS findings or investigation might add to the administration in that area. But in many cases, not that it's just unfounded. In many cases, it's that they won't even take the case after the referral have been made. And sometime I have hear some people defending, but DCFS didn't took the case. And I say, we work independently. They have their set of rules and their goals, what they're trying to achieve, but the district have policies and practices, and we also have that same interest. So we have different operations in that area, although we benefit. And there have been cases where DCFS have made a recommendation and have found it, and we have obviously incorporated that in the recommendation of the administration. to the
Okay,
board.
I'm going to table that because that needs to be fleshed out, but that can happen at a different time. For investigations, like in the situation you had previously given where 2 days in, they want to go ahead and resign. I don't know what it looks like for us to finish the investigation and keep them on a leave of some sort.
So it depends. And again, if it is something that the employee is going to resign and then they leave the vicinity and we have no ability to get information from them, we either have to conclude the investigation based on the information we have, and they have elected to waive their opportunity to weigh in, and you could proceed through that. You're basically acting in absentia, right? You're convicting in absentia if you were in a court. You're making that decision that way. There may be reasons why, and I've had these conversations where I've said, you could resign, but you should keep in mind this involves sexual misconduct. And if you ever try to get employed in another school setting in Illinois and some other states that have this rule, we would have to report to them that you resigned after an allegation of sexual misconduct and there was no finding.
Can I clarify that? That's against students, though. That's not
That is
against
true.
staff.
That is true.
So
But
that's, yeah.
it's a comparable conversation. But at the end of the day, it's up to the employee to decide what action they want to take, whether they want to resign and proceed to present that, whether you want to accept it. If you didn't accept it, if they're not a teacher, you can't force them to continue to work for you. It would move to job abandonment, and then they'd say, but I resigned, how can you say I abandoned my job? So there are just some issues there. Lots of times, and most employers, when you're looking at resignation in lieu of termination, you're getting clarity in expectations, and you're getting efficiency in closing an employment matter.
Yeah, for me personally, board, it is concerning when it's a safety-related investigation, and then if they're not against a student and we accept the resignation, again, we're passing the lemons and allowing them to potentially re-perpetrate in a different district against adults. So that's where I have concerns. I hear you, Mr. Riddle, on the cost of what termination and litigation would be. For me, I think that allows perpetrators to continue to do what they want. Well, it's like, it's gonna cost too much for them to come after me, so I'm gonna do what I wanna do. So I have some hesitancy going along with that, because that could just be a cover that they go under.
I was asking, I'm not saying we should do that. I was just asking, was that a consideration that the district had, and was there a threshold whereon, they felt it was to the district's benefit to take the resignation instead of pursue a termination?
Yeah.
That not necessarily anything to do with sexual, I wanted to know what cases, if that's a consideration our district uses.
And I'm wondering, with everything that Mr. Riddle said, Ms. Lindsay said, what I said, should this be put in policy? See, what we put in policy, okay, is what the direction that the administration gets.
Sorry, to jump on that, I thought after this conversation, we would expect it to come through in policy, or is that my misunderstanding and jumping to
It will all
conclusions?
depend on where you land.
Got it,
Whether it comes in policy, how we would bring that forward.
got it, okay.
I do just want to say one other thing, and this is an example of that. One thing you could do, which is a middle ground between resign or terminate, is you could give a direction that you need on the personnel action schedule to say when it is a resignation in lieu of termination. Then everybody will know, and it will be very transparent.
I like transparency, so I love that. I think, because there's Under the school code teacher dismissals and generally, the last bullet is whenever, in its opinion, the interest of the schools require it. It happens in our schools, and it's unfortunate to say this, but we do have some teachers that do not love our kids. We have some teachers that look at a second grade boy and say, you're not cut out for college, you're going to the military. So I don't necessarily think that should be a termination, but I don't know if we're following that aspect of the school code when parents are raising these concerns of how teachers are treating their students. The last point I'll make, Ms. Hanna, and then I'll be quiet for a while. Under that same one for the egregious conduct, where it says irremediable conduct or performance deficiencies. So can you clarify and provide some examples on how you come to that determination? And then I do have one follow-up, but I'll hold it after a
Sure.
while.
I think your easiest example is through the evaluation process. You've done remediation plans, you've done professional development plans, you've done your appropriate evaluations. You may be into tenure at this point and not a probationary teacher. So it's really going to play out probably more with that, because if you're probationary and you're not meeting performance expectations, there's likely to be evaluations that support that, efforts to bring their skills up to speed, and then a recommendation at the end of the year for non-renewal because they're still probationary. But on the tenured end, you're going to have those professional development plans, and we still have the same problem in the same areas. And we have the provision in the school code that says if you are unsatisfactory as a tenured teacher, you do your 90-day remediation plan, and you're still unsatisfactory or needs improvement, then you must be presented for termination to the board. So that's where I think that is most likely to arise, but I always leave the door open for you never know what a fact pattern might bring forward.
Okay,
So, do you want to ask a question?
I do, I just, because we're on with the, is it on?
There you go, you're on.
It keeps
Oh,
dying.
do you want this one?
That. Hello, hello, hello. Okay. Going back to having to report sexual misconduct with a staff to a student, okay? And I thought, and this was before, okay, before you became general counsel, I thought that a law had been put in place covering staff going to another district. And in other words, if we did not terminate and that staff went to another district, did the same thing, because we didn't both terminate and or report that staff, that our district has a liability on that.
So the facts are going to control, as always. We have tort immunity protections as a general rule for decisions that are made in your official capacity. And ultimately, liability would likely only apply, we might be in the lawsuit, but we would likely only be liable if we could show deliberate indifference and willful conduct in failing to report. And before I got on, some of the changes in the rules that I've put forward here about face law and the willful or negligent failure to report, those weren't in place historically. They're relatively new.
Right, I know.
Okay.
Yeah, okay, and then going back to teacher resignations, the generally during school term and summer. I got a question. Okay, just say we get a teacher that wants to resign, right? But because it is within those, for simplification, those restricted times, so to speak, right? And we say, no, you can't resign. That scares me. Because if someone doesn't want to be somewhere, I'm afraid that the teacher would be hostile to the students because they want to leave. They don't want to be here, but we're saying, no, you can't leave
So I can,
because of the restrictions. So that's scary to me.
I agree with you, Ms. Hannah. I'm just going to go back. And so now I'm going to be a teacher in the workshop. So just to finish that one off, the board had a discussion on that, and it was a consensus of the board that we were going to hold license if teachers did not give us the right amount of notice of leaving. As a result, HR has already sent out notification to our teachers that we would be starting that in January. So I believe the board has solved for that problem and has made a decision. So now here is the question that's on the table, because I'm going to try to bring us in. So here's the question, and bear with me. As a board, do you feel there are certain infractions that are terminable offenses you do not want to accept the resignation for versus termination? So can I get a consensus on that? So yes, so the board, as a board, we're saying there's some offenses, we are not going to accept your resignation, we are going for termination.
But
Okay.
what offenses?
Now, I'm going, thank you.
Oh,
Miss
okay,
Miss Hannah, come sit over here by me. We on the same page. If that is a yes, now I have Miss Maluski. Oh, sorry. Miss Howlett, I didn't see behind you. I have Miss Howlett behind me. What are those infractions that you will not accept a resignation in lieu of termination? Okay, so Ms. Ramirez said anything that needs to be reported to ISB. Okay, so do we have consensus? Can we have consensus on Ms. Ramirez's point?
Yes.
Anything that has to be reported to ISB, we will not accept a resignation in lieu of termination. Okay, number one. Number two, anything else you want to put on the table right now? We could just throw it in the parking
Yeah.
lot and have some discussion.
Physical fighting among staff
Okay.
within the school district.
Okay, so I'm gonna repeat what I'm hearing, and you can tell me if I'm on the mark or off. So you're saying altercations from staff member to staff member, altercations from staff member to student, altercations from staff member to stakeholder, and that means parents. Do we all agree with that? I put the parents in there, and I went back to Ms. Lenzine, because I'm adding what everybody's been saying at the table. So if you're not okay with that, just say no, Ms. Hannah, but it's everyone.
I need a clarification. Mrs. Hannah's statement was physical fighting. Ms. Lenzing earlier raised a more nebulous concept of physical or emotional safety.
Kathy, can you give me 1 minute? We're gonna get there,
Okay?
because we can't take it
That's-
all.
I need
It's
that-
gonna confuse them. Let's go with,
You switched it, though, to altercation, so are we
I
still
didn't
talking
say
about
verbal.
physical?
I'm talking physical
Physical.
altercation.
All right,
I'm
that's
on the
what I wanted.
physical. I'm on the
Thank you.
physical. So what I'm hearing, and you could say, as a board, you can say, I like 1 and 2, I'm not crazy about 3, right? So we'll go through number 1. Do we agree with altercation of a staff member with another staff member, we would not accept the resignation?
As the aggressor, right? Like if you were the aggressor, because if our staff is defending themselves, they shouldn't get terminated for it. So when you are the aggressor in a physical altercation, grounds for termination.
Well, okay, so if you are the aggressor on school property, or at a school event, do we agree that we will not accept a resignation in lieu of termination? Can I get a consensus on that?
Yes.
This is, concession that someone defending themselves, that's not,
We said the aggressor.
yes, the aggressor.
Okay, okay, the aggressor.
Yes.
Do we have consensus on that? So what we're stating now is that if there's an altercation from a physical altercation from staff member, the aggressor, we will not accept a resignation in lieu of termination.
Are we adding on school property or at a school event?
We could do both.
But, right, you didn't add a location to it.
Okay.
So under what you had said, it could be, you guys could be at Jewel and get into a.
Got it.
No.
No. So, yeah.
That's in the city.
That's fair. That's fair. So on school ground or at a school event?
Absolutely.
Right, okay.
Okay, so are we in agreement with that?
Yes.
So that was staff on staff.
Staff on staff, the aggressor, on school property, school event.
Right.
I thought it was staff on stakeholder.
Well, we're going with the staff on staff, then we're taking the second one. Okay, got it? So do we agree with the staff on staff?
Yes.
Yes.
Okay, you got that? Second part of this is, do we agree that if a staff, the aggressor, has an physical altercation with the students on school grounds or at a school event, we would not accept resignation in lieu of termination? That's the discussion you all need to have.
That is,
If they are the aggressor, if the staff is the aggressor, I'm 100% 10 toes down, yes.
Right, yes, but not defending themselves. Okay, because, the child,
you get,
it has to be spelled out.
right.
We're gonna spell it out, but we're saying aggressor, so we're using that word right now. We'll get more granular with that. So can I get the temperature of the room? Can we go around? Mr. Riddle, yes? Yes? Yes, yes, yes. Okay.
And that's something you recommend.
What about Mr. McBride?
No, this is you, I recommended mine. You guys are taking this.
Mr.
Oh,
McBride.
Mr. McBride, I'm sorry.
Look, you ain't no statue over there, man.
So sorry, Mr. McBride. Ms. McBride, are you in agreement? I apologize, Mr. McBride. Thank you, Ms. Hannah. Thank you. I did not do that intentionally. You know that. I so apologize. Okay. So are we in all agreement?
But we have to define physical aggression. It's not a staff member putting their arm around holding.
No, not a CPI
Right.
hold, none of that. We're
Right.
gonna if I come up and.
Physical, that's right.
Okay,
That's right.
Clarify that.
That's right.
perfect.
Because
We will.
sometimes.
You're gonna see this, so we're taking notes. The third part of this now is I use stakeholder, but we said parents, right? I agree. So if we have a staff member have a physical altercation with a stakeholder on school property or a school event, do we agree that that's a termination versus resignation in lieu of termination?
That includes board members,
Thank you.
aggression against the board member.
Well, we're a stakeholder.
Yes.
But you know what? You know what?
That's your
Stakeholder to
discussion.
me is so generic. And there's been those instances with more parents than when somebody says stakeholder, that's the businessman down the street or the organization. That's kind of few and far between. So I would like to see it specify parents.
I'm fine if we do parents and other stakeholders, if you want that clarification.
parents.
But we have community partnerships all around.
Right,
And
but
I would
they're
hate
not-
for someone from Waukegan to college to get clocked because the staff member's having a bad day and they're the aggressor, right? So I understand it's few and far between, it's less
Right.
likely to happen, but should it happen, we hope none of this ever happens.
But we have more instances with parents.
And sure, so I'm fine
so-
with making it parents and other stakeholders. If
Okay,
we want to make sure that
that's
is emboldened, that's totally fine, but I don't want to cut out anybody else from that pie.
Right, but, yeah, so, yeah, whatever, just.
So
make
can I
sure
get a
parents-
consensus from the board?
And on-
Can I get a consensus from the board? We're looking at Mr. McBride first. Okay?
Kathy, should we go parents and guardians? Because not all of our primary for the students.
See, all of it could
We
be-
define parents to include legal guardians in your
Right.
policies.
Right.
Thank you. Okay, now, there was another one around emotional health, and I'm going to let you term those the 3 ways. Is that okay? Because you brought that in. Is that all right? So we could get, I don't want to mess that up.
Okay, go ahead.
So if you are emotionally abusive, right? So when you go into your workplace and someone doesn't like you because you're a practicing Christian and they are constantly on top of you like God's not real, this, that, and they're constantly going after you and just being disrespectful, excluding you from meetings, excluding you from lunches, excluding you from events because of that, yes, that's discrimination, but the language on top of that, if it doesn't necessarily rise to a legal definition of discrimination, but you feel unsafe going into the workplace, or if someone uses a racial slur, or if someone just doesn't like your personality and they are moving in a way that is causing you it's emotional abuse, I don't think you should be in our district.
I agree. And on that note, I'm thinking more in terms of children.
It's the 3
children
categories.
In the children, in terms of the emotional harm, I'm not real certain. I know that in the child, what is it, Kathy? The Child Act?
Abused and Neglected Child Reporting Act.
Yeah. In there, they talk about that emotional stuff in there, in that law or that act. I have always kind of disagreed with that because kids are going to be emotional.
Ooh, okay, let's back it up.
Kids are going to be emotional by nature. In terms of an adult causing emotion, a child to be emotionally abused or something like that. I know what I'm saying. Maybe I'm not articulating it, but that's something that needs to be discussed and kind of narrowed down.
We
a
can
little bit
pull up
more.
a more legal definition of what constitutes as emotional abuse. And children, I'm not going to say are more emotional. I feel they have less regulation over their emotions, right? And so if we have a teacher that is standing in a classroom like, you're not going to be anything, why are you even trying?
Oh, yeah.
I'm teaching in the
That's
ghetto.
misconduct, as far as I'm concerned.
And we should not
That's-
let them resign. We should terminate
Terminate
them.
them.
Because that is a message to our community that we care about the emotional well-being of your
Okay,
kid in
I
our schools.
understand. I understand what you're saying, and I agree.
Okay.
That's so much harder to document, though.
Right, I guess that's what I'm saying.
I would think, yeah. I don't think I could support that as a, just a blanket.
I
issue.
think we need to get a more legal definition, but there have been instances where it's either, I think,
Normally, it's longer term, too. It's not just one
Right.
incident. So, there's a range there.
I got an example.
Yeah. Oh, here.
I got an example of that, this very thing, just yesterday. And I'm not going any further about it, okay? But it's what you're talking about, but things can be said, like the parent's gonna say one thing, right? And you have to be certain that the story is the factual story. And, I'm not saying that a parent would lie, but a parent is going to side with what the child says that took place, okay? And that's just the times that we're in. When we were in school, if the teacher said it, you did it. It's not like that anymore. And go ahead, Superintendent. All the batteries going out.
this one's kind of working.
I'm tracking with you. I want to remind the board that this is just not one incident where you said something. These are investigations that took place where we found there was egregious emotional abuse, disturbance, whatever. So this is not just, you talked to me some kind of way, it didn't land right. These are formal investigations where students are being and our staff needs protection too. We don't need our staff to work in fear. What they need to know is what is required, what is expected, and how we're supporting them through this, right? So it's not a got you, but it is that's why when I had a racial slur, if a racial slur is used, that would be a formal investigation, and based off that, because that's emotional abuse, right? What would be the stance of the board once we said yes, a slur was used, it was egregious? Would you accept the resignation or would you want the termination? That.
It needs to be narrowed down, okay? I mean, a racial slur is a racial slur, but I think it needs to be more specific in terms of the definition or what we're going to say happened, or what we're going to charge the teacher, the perpetrator, or whatever. I think it needs to be specific. You can't just
I think we can place something in there to accept terminations based on emotional abuse, because one, as a board, I'm hoping that the opponent accountability with our administration has been that once they bring something to us, that there has been a long and extensive and thorough investigation done. I don't necessarily agree, Ms. Hannah, that we have to be very, very specific, because we can also reserve our right not to accept that termination.
No, I understand,
So I think that we just need to ensure that the investigation portion is being followed according to school board and according to school policy. So therefore, when you bring it to us, we know that it's egregious and it's something that we must take absolute action on now. For us to put in a list of what we think is egregious means that us as a board do not trust that point of accountability of them being able to follow school code and school policy. So I do believe that we can place something in there that we will not accept it, because again, we always have the right to reserve not to accept that termination. So I just believe we would be causing ourselves more work to be able to put A, B, C, D, E,
It
F,
needs to
G
be.
in there. Again, I think we're covered, because those are always points that we can discuss when we don't want to accept the termination.
But then if it's not specified in there, it's not going to be giving the administration a direction. They're gonna come back, well, this wasn't specified, but this isn't, you know, I just think that it's always better to be specific, and then there won't be any question.
I think one of the concerns maybe underlying why to have it be specific is there's distrust within the district for certain cases to be investigated appropriately. I'm not saying it's valid, invalid, whatever. I'm just saying there is that distrust there, right? So there have been situations where, in my opinion, it has been an interdepartmental or within a school disagreement, and it escalated into an investigation. I think it comes back to Ms. Ramirez's point of we need very thorough investigations to make sure that we, the board member, given facts. I don't want your opinions, I want the facts. And when we have the facts, we can then determine our opinion of, to me, this reads more as a department conflict, not emotional abuse because they disagreed with you that we should be serving apples every day in the lunchroom, right? That's just a silly example, but I don't want to give very specific ones. So I think it does come down to the details that we are given. But I think to Ms. Hannah's point, when my hope is this will be put in policy, but when we go to do that, giving some general examples so that staff are aware and you guys don't see an influx in investigations for things that are disagreements, right? So having some little vignettes of like,
That's
this is
why
a
I'm
scenario,
talking
right?
specific.
I know you want specifics, but I also don't want to hamstring us by, this is emotional abuse, but we didn't think about it in the moment. That's my only concern with that. Yeah.
Again, I think the egregious conduct is already listed here, and I think to spell it out, like you said, Ms. Ramirez, you know, we don't need to put A, B, C. You know, actions which are injurious to or endanger the health or the person of students in the classroom or school. You could list them if you wanted. A, intoxication, you know, B, emotional health. I mean, you could list all those things, but our staff is concerned about that. We have to, as you said, I believe that we trust, and they would come with an investigation. This isn't just a one-time thing. You know, so I don't know that we have to spell out all these things I think that covers it.
I think, but we just need to expand it because this, again, is just for students, and we need it for staff and stakeholders. So I agree with
Well, it says the classroom or the school. Oh, health or persons
in the classroom or school.
in the
So
classroom or school.
injurious of the student
Uh,
in the
per-
classroom or school, or endangers the health or safety.
It's still students, I guess.
Oh, my bad.
I just want to say, so everybody is aware, this conversation is really terribly helpful. We are capturing this. You will have a chance to revisit whether we captured your intent as a consensus when we come back to you with documentation. So the piece of physical harm, the policy currently being focused on student, we've got your recommendations. We need some expansion to staff there. we've done policies before. An example are our sexual harassment policies, where we say examples of include, but it's not limited to.
Yeah, beautiful. Yeah. Okay, that makes more sense. I apologize for misunderstanding.
May I add that you have some recent examples of as soon as the board start conveying their concerns about more transparency in those resignations items that you're considering in personal items, we have started, the administration has started to provide some more clarity in those. So even if you miss an item there, I think the good judgment of the HR department, the present and the near future will be that they will come and through the administration and the superintendent present that in closed session just to get your feelings before we bring the item for formal action and be a little bit of a situation where then in the middle of that process, we need to change that. I think that the mechanism that we used last time was we have these are the reasons, but we're moving into the area that if there is a concern or a doubt which way the board might act in some cases, we will bring that ahead of time and then we will proceed in the following meeting.
Oh, there I am. I'm going to jump in on that because I feel like in terms of the cost, if there's litigation, in that process, we're also being advised on the likelihood. Like, are we in good standing? Should they combat us? Do we have enough documentation? Do we have enough evidence to say, no, we're full within our rights to have terminated this individual? So I do like that process. Can I get clarification, because it was mentioned earlier. So is the staff asking to resign instead of being terminated? Or is HR offering that opportunity as an avenue?
The past practice was that we were asking for the resignation in lieu of making a recommendation to the Board of Education for termination.
Okay. So I personally don't, yeah.
There are times when they will ask us,
Yeah.
To do that.
will the board accept a resignation in lieu of termination? So we have
yeah.
had both situations.
I'm totally fine if the staff wants to ask. I feel uncomfortable offering that as an avenue. Because if the principal is saying we should terminate, if an administrator is saying we should terminate, I don't think our HR representative should be going around their expertise to say, no, let's have you resign instead. So I don't know how the rest of the board feels about that, but for me, I've always been a little uncomfortable with
Well, I have
HR
to
leading
disagree
that.
with you because the expertise resides in HR and legal and in consultation with the executive team of the district, how the district wants to proceed. It's a recommendation from the principals. They have recommendation for termination, recommendation for hirings. Sometimes I have to stop a hiring because we already reviewed some of the issues that won't allow us to employ certain individuals. So we need to filter that. It doesn't necessarily mean that we're not going to be in agreement, but we have to have a discussion at the district level through the superintendent before we come to the board and make that formal recommendation.
I think there needs to be transparency or clarity around how HR is determining this should be a resignation instead of termination.
Yeah. We hear you.
That to me is exactly what this discussion is, giving us those guidelines.
Yeah.
But to the point of the principal is recommending termination, usually what they're saying is, this person no longer needs to be our employee. I don't want to speak for the principals. I don't know that they're saying to us, you need to terminate versus if they wanted to resign, you shouldn't do that. That is an HR function. That is a question of how the separation takes place versus whether the recommendation is that this individual should no longer work for us.
So I think that language is very important. We should have them use the appropriate language, right? Because if we are saying in, I believe it's the school code, right, that says the principal recommends, yeah, to the superintendent, but recommends what?
Superintendent recommend hirings and and dismissals.
Make retention
termination.
recommendations. So. Yeah, okay, got it.
I'm struggling, should I say this or not? Usually when you struggle, you shouldn't say it. But, yeah, I think previously there has been a misconception that the admin and the board, us as a group, do not like to terminate, and we don't. We would prefer not to terminate, right? So there's staff members that will use that resignation because they don't, the process and don't know if they're going to, support and stuff like that. So I think as we build this out, you're correct. They're going to have clarity. They're going to have transparency. They're going to know where the board stands, and they're going to know where they stand because we've outlined it more, where before it was a little gray. So I think this is going to help us.
Now, this is for not employee separation. That includes everyone.
Yes, ma'am. Everyone.
Okay.
Everyone's
Okay.
sitting at this table too.
Right. And I liked what Ms. Lensing said. I think always, I worked for a former employer where when we wanted to terminate somebody or wanted somebody out, we just wanted them out. And so sometimes we just said, we're going to terminate you unless you want to resign. But here, we have a safety issue. We're concerned, about the safety of our children especially. So we don't want that person going out, some of them, and getting a job in another school if it's been a sexual misconduct or something. So I think that's always the issue. The prime issue is the safety and concern of what this individual might do on the outside. And so some individuals we need to terminate so there's a record. And we don't, when an employer calls, we're not going to tell them what they did. We're limited on what we can tell them, but can we tell them, Kathy, that there was a termination? Or if we had to report it to ISB, we at least, it depends, lawyer. It depends, but nevertheless, there's always that safety issue. And that should be our top priority, safety. You keep saying that, and that's what we need.
Yeah, that's my guiding pillar. To your point, though, even if we can't necessarily they call HR, oh, did they work for you? Oh, why were they, stopped working for you? Perhaps they can't, but it is part of public document in our board docs and in our meetings that this individual was terminated. Yeah, the next school, any good hiring staff is looking at that prior district and doing a little bit of digging. Now the internet has most of everything about you.
So I'm gonna stay in my teacher mode. So we've talked about physical altercations, we've talked about emotional safety. Is there anything else that you want to add to that list? Because I'm gonna bring something that you feel we will not accept the resignation for. We will only take the termination. Does any other board member want to add anything to put on that list for discussion right now?
The only other thing I have is about our ESP dismissals, and they're not necessarily currently required to report if they witness something.
They are mandated reporters.
They are still mandated.
Yes.
Okay.
Every school employee, no matter what your position, is a mandated reporter.
But this
What
says
that
maybe.
says,
Yeah.
what that says is if I'm a maintenance worker,
Yeah.
and I see a teacher hit a student,
Mm-hmm.
and I go, boy, that's not right. I think that's abuse. And then I do nothing. I have willfully failed to report. If I didn't report because I didn't know I had to report, or I didn't report because I thought Mr. Riddle saw it and reported it, well, did you check? No. That's negligent failure to report.
Okay.
And the school code says if that happens, except for teachers, because teachers have some different rights under a different part of the school code, you as a board may consider that to be grounds for termination. It doesn't say you have to terminate. Terminations are always, I'm going to reiterate this, always case by case. This discussion is, do we allow resignation in lieu of termination? That resignation could come just after they've learned what the charge is that we're going to investigate. It could come in the middle of it. It could come when we're done. And they know a recommendation is coming for termination. We get it at all different points in time.
So are you gonna put all of this, everything that we're talking about tonight, right, and a second meeting if we have time, are you going to devise a policy or policies around what we have talked about today for our
Yes.
perusal and
Yes.
Yes.
approval?
We will look at, again, the code of conduct policy. We will look at the resignation policy. We could end up with language that says, this directs the superintendent to develop specific guidelines that incorporates these areas, because that gives us a little more flexibility as an administration and board to respond to things that change on the ground. Exactly what it will look like, we'll be working on over the next several weeks. And then we will be bringing it back to the board for that change to be put in place. And then after that, we roll it out with training and notification and all of that.
And you'll have multiple times to look at it, give input, say, hey, I see this, but I didn't think about this, so what about this? Like we do with every other policy. We've made a lot of ground today, and we have a good foundation of where to start at. So I'm gonna ask one more time, is there anything else we wanna put up there? Because if you think of something later, Ms. Hannah or anyone else, you can say, oh, I didn't think about this, but what about this? And we'll be discussing it during when we're, discussing policy, well, it's this or it's that. So it's not said, done.
That failure to report, it might be a coach, it might be one of our other staff that has a conversation with the young person and they reveal something to them. Or, the coach, sees something, when the guy changes his shirt, or whatever it is, some marks on his back, or whatever. I think that's that person, all our staff need to know, including our board members, that failure to report is subject to termination. I'd like to see that. I don't know if you all consent on that, but don't you think that's pretty serious? Failure to report
So-
suspected abuse?
Yeah, so I'm gonna just poll, because that's what I'm just gonna, so Mr. Riddle is putting on the table that if an employee does not report an incident, that we would go child abuse, or if somebody said, that I'm having an inappropriate touching at home and doesn't tell anybody else. Are we in agreement that for that type of case, we would go for termination versus if through a formal investigation, it was found that this employee had knowledge of it, didn't tell, we got to go through the formal investigation, so I don't want to just go straight to the point. What does the board agree that if the failure to report, we will not accept resignation, we would go straight for termination? That's what you're saying. Did I capture that correctly?
My only caveat is that we, as a district, if we're going to add that in, need to make sure that that type of training is done before the school year starts. So I don't know if HR needs to connect whoever's in charge of trainings to make sure that these safety-based trainings, whether it's sexual harassment, whether it's bloodborne pathogens, whether it's faith law, all of the ones that impact safety for themselves and for others, that needs to happen before they interact with students. Because if it's not, it's hard to hold someone accountable if we're not doing our due diligence to ensure that they are informed.
And I'm glad to report that since I was a teacher, okay, and that's years ago, the district, the schools, every year at the start of the school year, that's one of the items that the principals in their first meeting with their staff discussed. That continued when I was a principal, and it's my belief that that still is ongoing.
I want to manage expectations. So we cannot require any staff to take trainings when they're not on the clock. Right? So we have to remember that once they come back, they have a few days without students. So at times, those trainings are not done. It's impossible. They're setting up rooms, but they have a window to get them done with deadlines from the district. So you said before they see children, that may not be feasible here because of the timeline of when they come back versus when students are sitting in front of them. However, there is an understanding that you have to take mandated reporting training. Give me one. Yes. So we're all taking those trainings, and then there's a due date. Now, I'm going to go to last year. We were monitoring the training, and for staff who didn't take trainings, there would be reminders and then progressive discipline if it didn't happen, right? And so Mr. Moulton is in charge of that, of looking at that list to ensure that everybody has taken the training, or if not, we're escalating on the levels. So hypothetically, I worked in your district, I know I was supposed to take it, it's January, I still haven't taken it. There should be communication to me that why have you not taken this training, and accountability for me on that part. So just so you know, it may not be before students come in, but there is a requirement to take it within a window.
Are staff notified when they're hired that they're mandated reporters?
And they need to sign a document acknowledging that they receive board policies and what their obligations are as mandated reported. Every staff member.
So that covers everybody.
Absolutely, no exception, sir.
Okay, and I got one last question, and Mr. Riddle provoked the question in terms of our coaches. Okay, our coaches are kind of on a different level in terms of, right, but what I'm saying is that coaches can be rough, but, and Mr. McBride, please help me with this. Coaches can be rough, but it's not, it's more in like more training type stuff, okay? And, you know, people may hear the coaches being harsh or, you know, rough talking with students. So I hope that we don't get that mixed up with what was being said about emotional abuse, because that's something totally different.
I'm gonna disagree.
Well,
And
of
it's
course.
because here's the thing, and it's come out, and like we can look at not in our district. I know there have been some concerns within our district, but let's look at how some Texas coaches have interacted with their high school students. Yes, you want to encourage these kids, you want to push them, but in no way should you demean them or emotionally abuse them. You shouldn't be saying, move your fat A across that field. Well, I understand, but there are instances where that has happened recently in our district. And so while yes, we want our coaches to like push our kids, there is that line. So I think perhaps that's another conversation we can get into the weeds on, but I think coaches should definitely be made aware of what emotional abuse will look like.
So all of that training takes place. I'm going to ask, because we're kind of getting circular in our conversation, if we can have Ms. Ramirez, your comment, and I know the superintendent had one more thing you wanted to raise.
Wait.
And then maybe we can bring tonight to a close.
Perfect. Go ahead. Did you have?
So the only thing that I have to say is regarding, I'm glad that we have the trainings. I know as a former employee, I've experienced that when we have to do our trainings. I know there's a timeline. I've been the employee that has gotten the warning emails of finishing them. So I know that we do get them, right? But here's where organizational efficiency and our goal to organizational excellence makes a big point of what goes into board policy. Now we have to utilize those reports that you're saying,
Yes.
right? We can't wait till January
You're
to see them.
absolutely right.
We have to review them monthly. We have to review them 30 days. You know, there has to be something that says 30 days of employment. We have to make sure that they have them, because here is the problem, that if we don't do our SOPs, if we don't follow our systems of operation, if we don't put those rules of organizational, you know, in place, then whatever we discuss here as a board becomes null and void if we are not running those reports, if we're not reviewing them, if we're not using them as tools of management and discipline and all of that, and then everything just comes into a hole that we're spending this money for these software and these trainings and these reports, but then we're not using them to create the organizational excellence that we need to function as an organization. Because whether we like to see it or not, there are two aspects of school. There is the social aspect, then there's the business aspect. We are in the business of education, and we need to run it in some organizational, efficient way. So if we're not going to look at these reports on training, then what are we spending the money on when it comes to this software? So as a board, we also have to be hearing that, yes, we're doing these trainings, and we have a 98% success rate 30 days going in. All right? Or we have to come to this person that refuses to do these trainings. There are people who just think they are a waste of time. There are people who just hit that start, hit that next, hit that next, hit that next, and whether or not they got a passing grade or not, it doesn't matter. Those reports are made there for us to find those individuals, and if we don't start utilizing all those systems that we have in place, what we discuss here today has been a waste of time.
And this is where the board holds the administration accountable. That's the accountability that you put on us. And you're absolutely right, because previously we were not using it like that. Mr. Moulton has been charged with that since the previous school year. We took a more granular approach on this, and that is the consistent basis of it now that we're looking at it, and we're utilizing either support, progressive discipline, wherever that falls. I have two questions, and I'm going to try to get you out of here within the next 10 minutes. Do I have consensus on what Mr. Riddle has put on the table? Because we did not take a consensus. Yeah, the failure to report. Okay, and the last question I have, and then the last question is, our stance is, if you lie during a formal investigation, we go for termination. We are not moving from that. My question to the board is, do you want to take those on a case-to-case basis? Or do you want to say, we will only accept termination based off resignation? If you want me to give you my opinion, I believe you need to take them on a case-to-case basis, and you do get to hear the case, you get to look at it. Or the opposite is, you can say, after formal investigation, if they're found to be lying during the formal investigation, we are going for termination. We will not accept their resignation. Where does the board stand on that?
I think the case-by-case basis makes the most sense. The reason I say that is because there are concerns of staff of, retaliation of if I tell the truth, even if it's a small thing, it's something that I can be fired for. Where if my, neighboring teacher does the exact same thing and handles it in the exact same way, they're not going to. So I think the case-by-case basis makes the most sense. I think it is on the administration to make it abundantly clear that we want you to be honest so that we can help the situation. And it's not, I want you to be honest and incriminate yourself and admit to this thing that you did so that we can fire you. There's a lot of trust rebuilding that needs to happen, and so until we have that as a stable basis, I think case by case makes the most sense.
That's fair.
I agree with that because there are different levels of severity of mistruths or lies, and some are going to be very severe violations, and some are not going to be. So I think it really needs to be taken on a case-by-case basis.
I agree with that as long as we understand that the investigation is a tool for us to find the truth. And sometimes the truth is that individual violated certain board policies that require us to act in a disciplinary way. So if we water down the tool, then will be open season for staff members to come and lie on their investigation for us then to be able to find the truth. We're searching for the truth.
We're really not watering down the tool, but we're just giving ourselves the opportunity to do a case-by-case determination.
Yeah, and that's how I perceived it. So what I'm hearing from the board, and I do agree, it's not watering down the tool. We're gonna still have the formal investigations. We're still, if we catch a lie, we will be going for termination. We may accept the resignation, but we will decide that on a case-to-case basis. Do I have consensus for that?
Wait, first, let me finish.
Okay, go ahead, Ms. Hannah, go ahead. No. Okay, go ahead.
Well, that's how my brain works. But, okay, in investigations makes people nervous. Makes people sometimes misspeak. It may not be intentionally lying. People are afraid, first of all, that they're, number one, they're under investigation. Number two, they're sitting in this room with all these people that can say, my livelihood is going to be gone or not. So, case by case, of course, but we also have to understand that there may be mitigating things that causes someone to misspeak. Okay, and it's not just because they're being, there's a malicious intent to lie. So that's my only caution.
So that is noted, and the admin is hearing you. So from now on a case-to-case basis, when we get to this point, we will present the case and we'll take them on a case-to-case basis. Sorry for the redundancy. So I think we've come to a very good common ground. I hope that the board feels that we've gotten a lot achieved tonight. I will tell you, I have a lot more clarity around this. And so I believe our team will be able to perform better for you in this area because now we have direction. I did hear about the accountability of reports and utilizing systems for effectiveness. 100%, Ms. Ramirez, that is what they're for. We need to be utilizing them. I will hold my team accountable for that. And I do want the board to know that we will have more time to look at this, flesh this out. Ms. Vanderbroek is going to go back and put a policy together. It'll come back, and then you guys can say, well, that's not what I meant. This is what I meant. I think I need to add this. So right now, it's a soft document. We're still working for it. And I do want to acknowledge that, Ms. Hannah, what you said is policy dictates practice. And so if you're setting the policy, it will dictate how we operate and the norms within this district. So I do want to acknowledge that you said that and it was right on the mark, because it will help us run, be a better school district with more transparency. And that's what we're all trying to do as a board. So I want to thank you this evening. Can we give Ms. Vanderbroek a round of applause for presenting tonight? You did a great job. And I'll turn it over to the board president.
It was really a good session, because this gave us a chance to really be very introspective and think about things that we really needed to think about and actually hear the other board members' positions on. So the thing about the next document that we get is going to be a draft. And the thing about a draft is we can look at it and say, well, you know what, maybe this isn't what I really meant to say, or this isn't what I wanted. And so we can review it and get a second draft or a third draft, as many as we need until we get it right. But this is a start. And I want to thank Superintendent Placencia for bringing us around to conclusion, because I like the way that you summarized everything. We're just covering a lot of ground, and you helped us kind of solidify it and put it into kind of an agreement that we're kind of all working towards. So thank you, and thank everybody for being here. This is very productive. And before I ask for a motion to adjourn, I'd like to ask, in the spirit of board member time, I'd like to ask if any board members have anything that they would like to say about any subject.
I'll make it brief. So Ms. Hannah, Mr. McBride, Ms. Fabian, and myself were able to attend the Dreamers Breakfast. Superintendent was there as well. And it was a lovely event put on by Waukegan Township. Ms. Fabian was acknowledged as a drum major this year. I know Ms. Hannah was last year. And I really appreciated, they had speaker Jesse Jackson Jr. come and speak before us. And it was just so wonderful for me to be able to just hear him speak and tie everything together about what we're seeing now in communities being terrorized by ICE is not congruent or in alignment with anything that Dr. King had envisioned for the future of America. So it's just nice to have attended an event where everyone is in community working toward the same goal, where we can all just live in this country and aspire to our hopes and dreams. So it was a beautiful event. Thank you, Mark Jones, and your entire team. And I just wanted to make sure that we acknowledge Ms. Fabian was a drum major this year.
Anybody else? Okay, in that case, I'd like to ask for a motion to adjourn. So, motion by Mr. McBride, second by Mr. Riddle. All in favor? Aye. Opposed? Motion carries. Meeting is adjourned at 8:37.